going to share a screen with you guys. So you start seeing a screen here, hopefully. I assume everyone can see this. So it's our Wills and Estates seminar, myself and Washim. So I want to just quickly go through a few slides. We're going to skip all these. Okay, this one is important. Wills and Estates disclaimer. So we both want to, advise you guys that this is a general education seminar. We're going to provide some basic information. You should not act on this advice until you get proper legal advice, because context matters, your circumstances matter, your situation matters. So make sure if you need to seek opinion, advice, consult with a professional. I'm sure Washim would be willing to do that. Myself, any other lawyer who practices in these areas would be able to assist you with that. So to begin with, as Muslims, I know most of the people here are probably Muslims, we want to understand the importance of a will, okay? In the Holy Quran, it is prescribed when death approaches any of you, if you leave any goods, that he make a bequest to parents and to next of kin. According to reasonable usage, this is due from the God-fearing. So we know this is an obligation on all of us. So it's a religious obligation, but in the Canadian context, is also a legal obligation. So what is a will? So we want to jump right into what is a will. It's a legal document. It takes effect upon the death of a person only. So prior to your death, the will has no effect, right? So there is a document which we'll talk about in a few minutes, power of attorney, living wills. Those do have effect while the person is still alive. So the will sets out your beneficiaries. It's important to remember, executors and guardians of any. Okay, so the beneficiaries are the people who are going to receive from your will. The executors are the people who will manage the estate, take care of the estate, and guardians are people who will take care of your children. They could all be the same people. So your beneficiary could be an executor and could be a guardian, okay? Or you could have non-beneficiaries be your executor and be your guardian of your children under 18. If you want to do a Islamic distribution, then you must have a will. And even then, there's some constraints and limitations, and we'll get to that when we get to the Islamic section. But essentially, if you want to try to distribute Islamically as close as possible, then you definitely need to do a will. If you don't do a will, then the legislation will govern, and we'll get to that shortly. The validity of the will. So who can, I'm going to rush through these early portions because they're not very, detail oriented, they're not very significant, but validity of a will. You must be 18 years of age and of sound mind. You can do a will if you're under 18, if you're married or contemplating marriage. Okay, so in some jurisdictions, you can marry at the age of 16, right? So the law provides that you can do that if you're contemplating marriage. Elderly, yes, you can. The issue becomes mental capacity. Do you have the mental capacity to do a will? All right, so that's a test. So when you go to a lawyer, when you come to our office, Wasim's office, any lawyer's office, they're going to assess you. Do you have the capacity? So you can't be lying on your deathbed and you don't have the mental capacity. And you say, I want to do a will. And we've gone to hospitals and then we say, well, we can't do the will because a person is obviously not in a capacity to do this. Okay, so you don't want to leave this to the end. If you have any past psychiatric issues, then mental incapacity also becomes an issue. Again, this happens quite a bit where people want to do a will and then we find out there's some psychiatric issues there, then we have to take additional steps. Limitations on a will, okay? So if you comply with all the rules of being able to write a will, then you can go and write a will. Now there are some limitations. Lots of people come to us, and I'm sure Washim will say the same thing, where people will come and they say, well, I have a house and it's jointly owned and I want, upon my death, I want my share to go to my children or whoever. Well, you can't do that because it's joint. So if you're spouses and the property's joint, irrespective of what it says in your will, the property belongs to the survivor, okay? There are certain exceptions and there are ways around it because it is what is known as a rebuttable presumption, okay? So the joint tenancy, general rule is it's going to go to the surviving spouse. But there are ways around it. There are ways to work around. these things, and there are things that you would need to discuss with the lawyer. It's too technical to get into here, but because the presumption is a rebuttable presumption, so the party can say, look, that was not what our intention was. We have evidence to substantiate this, etc., etc. Okay, but the general rule is property joint ownership. You cannot distribute it in your will because it doesn't belong to you. RRSPs, anything that you've named a beneficiary for, okay, it's already the designated beneficiary is already on the property or on the asset, so you can't deal with it in a will. Assets of a business dealt with under a partnership or shareholders agreement. Again, it depends on what your shareholders agreement says, what your partnership agreement says. This is why usually lawyers will do a consultation with you to get all this information. So it's not a question of just like, hey, can I just type up a form? A lot of people do that. They're just like, yeah, if you have no assets and no issues, yeah, go ahead and do a will. And Washim will talk to you about doing a holograph will in context where maybe you don't have significant assets and you don't have issues, corporate interests, and things that you need to deal with. Assets dealt with in a marriage contract, and I think Washim will talk about that when he talks about the family aspect of this. Again, may or may not be able to deal with in a will. This is why you need legal advice. May not apply to foreign assets. I know when this event was advertised, people were like, well, make sure you address foreign assets. Well, the law with respect to wills is the law of the domicile, right? So there's technical rules on, and there's conflict of laws rules with respect to different countries as to which laws are going to govern. So that's something you need to get legal advice, not only from a Canadian lawyer, but a lawyer in the jurisdiction that you have this asset in, okay? And of course, the limitation of the will is that it can always be challenged by dependents, okay? People can always challenge it. Like anything else, any contract, any agreements, they can be challenged. So limitations of a will, you don't have complete power to dispose, okay? There are certain limits. One of them, the Succession Law Reform Act basically says, certain people have to receive under your will, particularly when it comes to spouse. And I'm going to hand off the platform here to Washim to talk to you about that. But basically, the Succession Law Reform Act sets out who's entitled to whether there's a will, and even in some cases when there's a will. Okay, so Washim, you want to take over on the family aspect of this?
Sure. Would you like me to share the screen?
Yeah, sure. Let me. I have to unshare mine, I think, right?
Yeah, I think so.
Okay.
All right. So if I share, I have a PowerPoint. It's not as great as Faisal's, but try to work with it. Here it is.
You're on there, Washim?
I think we lost him.
Oh, lost Washim. Oh, okay. So let me, until he comes, let me go back to my screen. Okay, so limitation of the will. So we'll come back to the Family Law Act provision. Hopefully you can take that over. Islamic rules of inheritance. Okay, so a lot of people are concerned about or interested in doing Islamic rules. So a couple of things I want to mention about this. Okay, limitations are, of course, you do have the right to distribute your estate the way you want to. There are some limitations, one of them being the Family Law Act, which basically, hopefully Washim will come back and address that. If he doesn't, I'll try to address that at the end. But Islamic rules, there are certain distribution rules that are set out in a different context. And so when you try to marry that or mirror that onto the will rules in the Canadian context under the Family Law Act, there's going to be some tensions unless both parties agree and both parties work out these tensions. So let me give you an example. I think Washim is back. Let me just see. Washim, can you? We can't hear you. Washim, are you back?
No?
Yep, I can hear you now.
Sorry, on my MacBook, there's a touchpad. Mistakenly, just my finger touched the leave meeting.
Okay.
Sorry about the interruption. So thank you very much. I just wanted to touch base on a couple of things, and I will like to just click the share the button and this one. Now, can you see my screen?
Yep.
All right. So I'll briefly go over the family wills and family law. As Faisal covered, that there are certain limitations in the Succession Law Reform Act. One of the most important one is the family law. So what essentially family law does, so even if you have a will and you leave certain instructions in your will, your property distribution may not be done exactly in accordance with your will, depending on your on the how you are and how you address the family law situation. Number one, if you die and leave a will, your wife will have, or the other spouse will have 6 months to elect whether or not whether or not to proceed under the will or proceed in accordance with the family law. The reason is because the family law, the Succession Law Reform Act deems that when people die, a separation occurs. That's under family law as well as in Succession Law Reform Act. So if, let's say, your wife, after your death, decides to go under the Family Law Act, the law will deem it as you had a separation or divorce from your wife just the day before you died. So that's how it's going to be interpreted, and your properties will be equalized under the family law rules. Now, the equalization is, a lot of people think it's 50-50. Yes, it is 50-50, but there are a lot of exclusions, deductions apply. So in the end of the day, it's the net worth, and it's the net worth that gets shared with the other spouse. For example, let's say on your death, you leave $200,000 in your property, total property. Out of that, $100,000 is your debts and liabilities, and $100,000 is your net worth. That gets shared with your wife, $50,000, and the remaining $50,000 will be distributed in accordance with your will. Now, if you name your wife as a beneficiary in your will right now, or your husband as a beneficiary in your will, in addition to the 50% that your spouse gets based on her election of under the family law, your spouse will also get a share as you distributed in your will. So if you give one share to your wife as well, she'll get 50% plus one share. That's one thing about the family law. Second most important issue that you need to know is the dependents. One of the common mistakes that a lot of people make is don't address the dependents in their will, and what it does, it impacts a will in two ways. Number one, your dependents can actually make a claim, and a court will, in that case, if you don't leave anything specifically for your dependents, the court will look into the circumstance and see what is fair and just and how your dependent should be supported. Your dependent, there's some categories of dependents that are that have direct entitlements. For example, if you're currently paying spousal support or child support to your former ex-wife or husband, or to children from another marriage, then they get a priority, and your estate have to pay the child support to them. If you don't leave any instruction on that, the state will decide what is their entitlement and pay. Often, and I currently have a file, actually I'm working on it, where my client died without a will or anything, and he has a mother who is completely dependent on him. She's 75 years old, and now we are in a situation where we are making a claim against his estate to give support for the mother. And now in this kind of situations, the court will look what is appropriate and distribute the wills in that way, give them a share for the support of dependents in that way. The other important thing that you want to make sure when you are considering doing will, you need to talk to your lawyer, or also you need, if you're doing will on yourself, make sure that you cover this, is the guardianship of your children. And I practice family law. One of the common situations, a lot of people are in separation. A lot of people are single parent, have sole custody of their children. Now, if they die, or let's say you're separated from your husband, you have the sole custody. Now, some people during the separation agreement or court process make sure that they have an order from the court that in the event that the custodian parents die, the other parent gets the custody, but it's not automatic. You, in your will, you can also address that situation. And if you appoint someone as a guardian of the children, for custody matters as well as for the property matters, the guardianship will be valid only for 90 days. And within these 90 days, the person that you will be appointed, the person will be able to apply to the court to have a continuation of the appointment that you made. But if the person doesn't, then it expires. Make sure that this is an important concept that you need to understand, and you need to consider who will be the guardians of the property. Now, Brother Faisal mentioned one point earlier about the house and joint ownership. One of the things that that is important is the right of survivorship. If you are in joint tenancy, most people buy their house just husband and wife together without specifying a share. The difference between joint tenancy and tenancy in common is that in joint tenancy, if you die, your spouse becomes the full owner of the property. And the process to actually sever your joint tenancy and make it a tenancy in common is actually not very complicated. You need to speak with your real estate lawyer. There could be some simple steps that can be taken to sever the change the title, how you hold the title, and it can be converted to tenancy in common, which will make sure that you get the 50% or whatever the share of in the property, and your other spouse doesn't get everything. There is also an interesting part. One interesting way to deal with the family law situation, equalization, is by purchasing insurance, because insurance and pensions are credited against the equalization. For example, if you leave a will and your other spouse decides to go on their family law, she or he gets 50%, and then remaining 50% goes to your beneficiaries. Now, if you have an insurance and make your spouse a beneficiary, then whatever your spouse gets from your insurance will be credited against the equalization. And the insurance might be enough to pay off your equalization. So you need to discuss this with an insurance consultant and sort out how you can make sure that your equalization obligation is paid off so that your beneficiaries receive full of your estate. And you can also have a separation agreement, not separation agreement, sorry, a marriage contract. Some people think that a marriage contract should be done just before the marriage as a prenuptial contract or after the separation. That's actually not correct. You can always do a marriage contract. You can speak to your spouse, like, if we die, we want to address this situation, so let's have a separation agreement that I give up my entitlement, you give up your entitlement over my property. A lot of people discuss this thing, they get independent legal advice, and they have a a marriage contract, which can also actually set out how your wife will proceed or your husband will proceed at the event of your death. And that could also bring a lot more certainty to your estate planning, to your wills. So I'll give it out to Brother Faisal to continue from where he stopped, and the other issues, if needed, I'll jump in. Thank you, Brother Faisal. I can't hear you, Faisal. You're mute.
Can you hear me now?
Now I can hear you, yeah.
Okay, thank you. Thank you very much, Washim. So there's a lot. So you can see from what Washim was talking about, there's a lot of issues that you need to consider. So it's not a simple thing of filling out a form. A lot of people will call us and say, well, we just want a simple will. So when we do that consultation, we will extract all this information from you, okay? And then we'll, based on that information we gather, then we can tell you what you need to do is this, what you need to do is this, what you need to consider is this, okay? So I think that's why it's important to speak to a professional in this area who can guide you through this. Let me just go through here next. Okay, the Islamic aspect we touched upon. So what Washim talked about, if you have a joint property, okay, and you don't sever the joint tenancy, what happens is upon, as Washim explained, it goes to the survivor, the right of survivorship. It's a rebuttable presumption, but for the sake of this, limited presentation, just treat it as if that's pretty automatic. It's going to go to your spouse, okay? But some people want it to say, look, actually this house is 50-50, 50 mine, 50 hers. And for my interest, my share, I want so much to go to her and so much to go to my children, so much to go to my parents, whatever it is, okay? Well, that can only happen if you sever the joint tenancy and make it tenants in common, okay? So there's a process to transfer the property, and you can do that. The problem with that, and we've seen this over the years, is people do that, and what happens then is upon the death of one of the parties, the other party only has a 50, okay? And the other people can come and say, well, I want you to sell this house now because I have part interest in this property. So this is something you want to think about. Is this something, because I've seen that I've been doing this for 24 years, and I've actually seen where the mother is kicked out of the house and they sell the property. Why? Because the kids want their share, okay? And then the mother has no job, has no income, and so she has to leave because they need to sell the property to get the 50% that belongs to the kid. So this is a consideration that you need to think about and have a chat with the family, but also your professional advisor, your lawyer, to see if there's something you want to do. So what happens if you don't have a will? Well, if you don't have a will, then the Succession Law Reform Act governs, and it lays out exactly how the distribution is going to take place. There's a lot of fear mongering out there that's saying, oh, if I die without a will, then the government's going to come and take everything. Imagine if that happened. Imagine if the governments could just go around grabbing people's stuff. You know what kind of uproar we would have? It doesn't happen. It goes through. What happens is it creates a lot of headache for your survivors, okay, because you don't have a will and you're leaving assets or young children, and you haven't specified who the guardians are, as Washim mentioned. You haven't specified how this is to be distributed. So now you leave the headache with the survivors. That's one thing. The second thing is you now have to follow the default law, which is set out in the Succession Law Reform Act. So you don't get to decide who gets what and how much. The government has decided this, okay? And if there's a long list of categories, I think 14 or 16 different categories of people who have to be not existing at the time of your death for the government to take it. So, you don't have children, you don't have wife, you don't have parents, you don't have siblings, you don't have this, you don't have that. And once that list is exhausted, then the government will come in and take it, okay? Now, if you don't have a will, as I said, the provincial law determines who the beneficiaries are, but also there's limited investment powers for the executor who gets appointed, because somebody will step in and say, I want to be the executor. In your will, you would have specified, I want these people to be my executors in this order. Without a will, somebody can step up and say, well, I'm one of these beneficiaries. I'm a person who can apply to be an executor. So you probate the estate and you appoint that person gets appointed. They have limited investment powers. It causes delay in distribution because there's disagreements, increased legal costs because you don't have a will to help, the lawyer through navigate this process. A public trustee will control the shares of minors until things are checked. Appointment of guardian for minors by the court, possibly. So if you leave minor children and you die and there's no will, or God forbid both father and mother pass away in a car accident and the kids are surviving, and you don't have a will where you specified who the guardian is going to be, well, now the appointment of the guardian may be done by the government, okay? Or unless somebody takes the initiative and goes to court and says, look, I'm going to be the executor. I think I should be given guardianship. Here's why my relationship, blah, 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 whatever it is, okay? It all varies in the specifics. Potential increased taxation. When you meet with a lawyer to do a will, they may decide, because the estates that you have, that we can do some estate planning. We can structure it in such a way that we can save you some money, okay, or your estate some money. We can do various things with your property, especially if it's free and clear, there's no mortgage on it. You have corporate interests, shares in a corporation, business interests, other things. We can help you structure these things to save you money. So it'll cost you money up front, of course, but it'll save you money down the road. So distribution without a will under the Succession Law Reform Act, this is what happened. This is what would happen. And Washim touched about that is basically the interplay between the Family Law Act, Succession Law Reform Act, other factors. Okay, so again, I'll share this slide with you, and I'm sure Washim will be willing to do the same thing. But basically, these are general information. Okay, so specifics are going to differ based on these scenarios. Okay, distribution without a will, a spouse and no children or grandchildren, then everything goes to spouse. A spouse, parents, brothers, sisters, and no children, everything goes to spouse, right? So you can see, just to give you an idea of what might happen. Distribution without a will, no spouse and no children, equally among the following: parents, no parents, brothers and sisters, their children step into their shoes, nephews, nieces, next of kin. So if no traceable kin, then government gets it. Okay, so the government is not going to jump in and take it, but you don't want to leave it in such a way without a will where all the headache, is felt by your survivors. Formalities of a will. Okay, no legal words are need to be used. You don't need legal jargon. Okay. Yeah.
Just wanted to add something
Sure.
before you move to the next topic. You know, what Brother Faisal said so far, it all sounds like all right, right? Okay, if I don't have a will, at least there's a way my estate is not going to be taken by the government. However, you need to understand that all these steps require significant amount of time and significant amount of stress. I had, just from practice experience, the last time in our firm, we asked for an appointment of a trustee because the person died without the will, and his wife asked for an appointment. And after like 11 months, the Ontario Public Guardian's Trustee's Office just contacted us. And then the court has contacted, the matter is just getting to the list. And it takes like several years to get one step done. Think about it. If you die, you don't have a will, just your mere simple bank account, if you don't have like the proper beneficiary and don't leave proper instructions to the bank, and it's not a joint bank account, just the bank account gets frozen. Your family can't even access that money that you hold in your personal bank account. And just to get access to that, you may need to wait years and go through the process to just have access to it. So although it is not going to be taken away by the government, it's not going to be easy for you for your family to access it. Sorry.
Very good. Thank you very much for that. So yeah, it's extremely important to do this because, as Washim said, you're going to go through a lot of it. And I'll give you an example where somebody says, okay, well, I don't have any assets, so why should I do a will? So let me give you an example where, again, this happened through our office a few years back, about 10 years ago. They died, both husband and wife died in a car accident, no will, and their bodies brought, they want to do a formal Islamic burial. The children are no longer Muslims. They want to cremate the body. Okay, so now the brothers and sisters of the deceased, they are like, no, they're Muslims. We have to do a proper Islamic burial. So had they done a will where they had expressed the intention, look, we are Muslims, we want to be buried, it would have been easily solved. But here what happened was the children wanted cremation. The siblings said they were Muslims, they wanted a burial, and if they had their wish, they would want to be buried Islamically. It ended up going to litigation, and the imams had to get involved to say, you know what, you guys fought as long as you can. By the time this gets through the courts, it's better that you did your best, but let the kids do what they can, because by the time you litigate this, and the costs, expenses, keeping the body in a cooler, all that stuff, you know what, you've expressed your intention, but you want to be in that position. So even if you don't have any assets, right, well, you have these issues that you could have possibly have dealt with a will. So this drive home the point that a will is extremely important, especially if you have assets, but even if not. Okay, formalities of a will, no legal words are needed. You need to identify the parties. You revoke a previous will. You have witnesses. Beneficiary or potential beneficiary cannot be the witness. You appoint a guardian for the minors. So they could be the same person as the executor. So I'm doing my will. I could say, look, I want everything to go to my spouse, my wife, let's say, just to make it simple. I want everything to go to my spouse because my children are very small, and it's going to go to my wife. My wife will take care of the children. Okay, so everything to the wife, and I want my wife to be my executor as well. And then of course my wife will be the guardian of the children. So it can be the same person, or it could be different people, right? My beneficiary could be my wife, but my executor, I want my brother to be the executor, and he doesn't get anything from the will, but he's the executor. And then I want my sister to be maybe the guardian of the children if me and my wife are deceased or whatever. Okay, so they could be different people. It's up to you. Codicils, if you hear that expression, are changes being made to the will. Typically, people will call us after they have a will for some time, and then they say, well, we want to make this change. So if it's simple enough, we might do just a codicil. But typically, because the length of time has gone and there's been significant changes, we suggest, why don't we do a new will, and we can help you do that. Let's see here. Execution. Signed in the presence of two witnesses, and I'm going to get Washim to jump in here as well in a minute. Initial each page of a will. So typically you would come into our office, or if you're doing it at home, you would have the will, and then you're going to sign in front of two witnesses. The witnesses do not need to know the content of your will. Okay, they're just witnessing your signature. They're identifying you, and they're basically saying the person signed. And then initial each page of the will, except the last one, because the last one is being signed. One witness then swears an affidavit. That affidavit, a lot of times people do the will and they don't do that affidavit. So I've had situations where people come, somebody dies, the executor walks in with the will, says, okay, where's the affidavit from the witness? Says, oh, you know what, the witness is also dead. Oh, now we can't do the affidavit. So it creates problems because when you do the probate, when you're probating the estate, you have to file the will and you file the affidavit. So because they didn't have legal advice at that time and they didn't know that you needed this affidavit, so now you have issues finding, locating, and possibly maybe never locating a witness, okay? The executor must be the age of majority, must consent to be an executor. You want to tell the executor, look, I want you to be the executor, preferably someone younger, although there's no guarantee that, of course, the person who's younger is going to survive, but likelihood is more. No executor or foreign executor, no executor. If you don't have an executor, then there's going to be issues of you having to get a bond. Or if you appoint a foreign executor, a lot of people will appoint, my sister in the United States will be my executor, right? Problem is, you can do it, but then when you do the probate application, the courts require a bond. And so the last bond we just did cost the person, the insurance company charged them $5,000 to indemnify the executor. Why? Because if you have a Canadian executor, if the Canadian executor takes over your assets, probating means the executor kind of takes over everything, and then the executor is going to distribute, right? So in the process of getting everything, what if the executor steals all your stuff or mismanages it? Well, if the Canadian executor is here, then we can have recourse to the Canadian courts and Canadian system. But if the executor is foreigner, they take all your stuff and they run out of the country, what's your recourse? So what the courts require is a bond. And to get that bond, you will have to pay, as I said, the last one we just did a few months ago, $5,000 right up front. Just a check is cut before we can even start the process of applying. Okay, and typically executive, family member, or friend. With that, I'll let Washim talk about the formality of signing will. As I said in the past, we just come in the office or sit somewhere and the witnesses are there. But now with COVID-19, there's different procedures, and I'll ask Washim to step in.
Yeah, thank you. So one of the fundamental requirements of wills is that it has to be witnessed by two witnesses, and the witnesses have to be in person present with the testator at the time of execution of a will. Now that created a lot of panic right now because of the social distance and the COVID-19, and the Ministry of Attorney General recently come up with a change in the regulation. However, there's still some sort of uncertainties and unclarity among the practitioners going on. I'll tell you exactly why. The first problem is now it is possible to do the virtual commissioning of will. So we can actually do that over the video conference. Now, the requirement is that if you do it, the there has to be the witness, people who are witnessing the will, the testator, the person who is doing the will, and a lawyer, all have to be present at the same time of our video conference. The session should be recorded. Now, one of the fundamental requirements is that one of the witnesses of your will has to be a lawyer or a member of the bar. Now, it's saying that the paralegals are also able to do that as their member of the bar as paralegal. I think I'm still not quite clear about that, but I don't see any problem being them a witness, but you need to check that. We still need to get more clarity on that. The second thing is like the witness has to be present at the same time. However, the most important requirement is that we all have to make sure that the document that is being signed and the signature is the same. And for that, you actually practically need 2 video conferences with your witness, unless you're already in the room with your witnesses. For example, let's say if you're doing a will virtually commissioning right now, you got a lawyer, you call me or Faisal. Faisal is on the video call with you. Now, you need 1 more witness. Now, if you are making a will and you're making your husband or your children beneficiary to your will, they should not be the witness, because that could lead to a presumption of invalidity. Someone can challenge your will. It's not itself an invalidity, but it could lead to that. And this is something you should be, it can be rebutted and established that the will is still genuine and valid, but that's a practice that you don't want to get involved with. So how do you do it? Now, let's say you have to call a friend or your cousin to be a witness. Now, if you do, your cousin, the lawyer, and you, all 3 of you have to be together on the first video call. And the first video call, the lawyer makes sure that you got the right document, and you show that to the video, and then you sign in the video that the lawyer and the witness both can see you're signing the document. And then you need to send this document to your lawyer's office. Now, your lawyer now has to validate it 1 more time, that it's the same document the lawyer sent to you and that you signed and over the video conference. Then your lawyer once again send it to the witness, the other witness you have. And the same protocol has to be followed. Saying again, you have to come to the video conference, lawyer has to come, and the other person has to come. And similarly, other person has to sign, showing the document first on the video, making sure it's the same document, signing on the bottom, attesting to your signature, that essentially saying that this is your signature and they're a witness to it. Then again, send it to your lawyer. Then your lawyer signs it again, validates it, and sends it back to you. So you can see it's a lot of steps that now you have to take with the virtual commissioning. And it's essentially doing the work like ordinarily in our office. We prepare a will, the client comes in, we have a law student or someone from our office, or they just bring in a friend, sign it, done. Right away, we sign an affidavit of execution. Now, if you want to do an affidavit of execution at the same time as well, then 1 more document you got to prepare and do. So a lot of complicated issues right now, even though you are allowed to do virtual commissioning. So you do really, if you really want to make a will, you need to start contacting your lawyer immediately, and you need to think about all this stuff, make appointments with your lawyer, a virtual appointment, have appointment made with your witness. And if you are, let's say, giving your entire estate to your spouse, not making your children beneficiary, and then children are age of majority, in that case, it's okay because you're living in the same house and you can do it's a little easier, but still the steps have to be followed, right? So Brother Faisal can say anything, take over from here.
Thank you very much. Yeah, so as you can see, it's made the work a lot more complicated for everyone, including the lawyers. It makes it, when it comes to, there's a lot of uncomfortableness when we're talking about lawyers and legal fees, right? Because one of the things about lawyers that we need to understand when we're talking about legal fees is, unlike you go into a store or you have products that you can buy, somebody can multiply the products, right? With a lawyer, what we're actually selling you is our time. So the lawyer's time is inventory. So when something now takes a lot more time, you can see, well, that means you can do less of it in a day, which means the costs go up, right? So this, it's not that lawyers are trying to make money and, you know, all the jokes out there, lawyers just billing and, you know, the level of time that's required to do things properly. Okay, you can do shortcuts, and there's lots of people doing shortcuts. But what happens is it ends up costing you possibly later. Okay, because when you do shortcuts, somewhere you're going to miss. When you do mass production, right? When you do mass production of these things, somewhere something is going to be missed, or I'm not going to be able to dedicate the time to sit there and extract the information that I need to give you the proper advice. Okay, you know, Washim will tell you that. I mean, people come to both of us because we're, you know, we're active in the community, and then, you know, if we quote a legal fee to them, they freak out. It's like, oh my God, you know, I thought. See, the problem is we have overheads, we have staff to pay, we have, and of course, our inventory is our time. Okay, but there are ways to do this. So if you have no assets, if you have assets and you have money, then you have to spend money to protect those things and to make sure things are done properly. If you have no money, if you have no assets, then the state does allow you and has provided opportunities to do what are known as holograph wills. Okay, so that's a simple will, and I'll let Washim just take over from there. So you don't have to do a formal will. If you have assets and you have children and minority children and you have other interests and things, then definitely you want to, I would be negligent to tell you, yeah, just go ahead and just do a simple will, okay? Because I don't know what your circumstances are. But if you don't have assets and you don't have these complexities, then we can't force you, nobody can force you to go to a lawyer and professionals and consult, but there's an option available, and I'll let Washim take over on that.
Thank you, Faisal. So another option, holographic will, it is as it sounds, it's a will that is written by hand. In Alberta, Manitoba, and Ontario, I think also in Saskatchewan, as a testator, you can actually make a valid will by handwriting your entire will. Now, if it is a holographic will, it doesn't necessarily have to meet all the stylistic or the technical requirements of the will, but it has to have the fundamental requirements of the will. For example, your as a testator, your capacity, your testamentary intent, and your will free from you know, undue influence, mistake, fraud. All this stuff has to be still applies. It just doesn't require you to have a will like with the sophisticated reference to the Ontario laws, these laws and that. The way when you go to a lawyer will do his due diligence, will prepare a formal valid will covering you from all this side. In some circumstances, the law allows you to do that. Just a simple will by handwritten. Now, these are the wills that you can do in some provinces, and you can just simply write it on a piece of paper. On a piece of paper with your own handwriting, that I so-and-so, and I, in the event of my death, this is my last testamentary intent, and this is what I want, this is how I want my property to be divided. Now, one of the most important requirements of this type of will is that you need to be very clear about your testamentary intent. What does that mean is that you need to be very clear in your writing that this is your will, this is your last wish that needs to be respected after your death, because it has to be different than a letter that you're writing to someone, or writing to your children, or something that you have just written, but you like something that you thought about, you wrote, but you don't know what to do with that. It has to be your intention has to be very clear in your writing that this is your will, and you want your properties to be your assets to be distributed in accordance to how you write it in the will. The other formality that you need to make sure that it is signed at the bottom, and it's your signature, and you need to leave the original with the like you need to make it available so that your executor can find it. Now, an interesting part of it is that if you write a letter to your lawyer, handwritten instruction, if you send it to a lawyer, and your lawyer to make a will, but you never got an opportunity, you die before you get to prepare a will or something, then actually in some circumstances the court actually found that to be a valid holographic will. So what you need to do for that, it's still like you need to make sure that all requirements of a holographic will apply is met there. You just is not properly drafted. Now, if there's some ambiguity in your will, some words are not clear, some words are not legible, then what can be done, the court will interpret, in a way that is understand and comprehensible, and the remaining part of your will be valid. So if you are choosing to do a holographic will, what is my recommendation? What I would recommend to someone is that you would consider doing this, especially for someone, hope people are not in that situation, but if somebody is in that situation that they're in, they have COVID symptom and they are in complete home isolation, they can't even go to the other room and see their family, wife and kids. So in that circumstance, what you should do is like you should at least write down your last intentions, your testamentary intentions, and how you want your properties to be distributed. You write them all down and in a piece of paper, and you write 2 copies of the same. One, you send it to a lawyer that you want to retain, or or you have consulted that this is my testamentary will. I as an instruction to the lawyer to prepare a will, and leave that as a will as well. So that would come into play in the event that you have an God forbid an unfortunate death. You will be able to your executor or trustee or beneficiaries will be able to claim that to be a valid will. And then if this is, remember one thing, if a holographic will is challenged, the burden is, like other wills, is on the people who are claiming this to be a valid will. For example, if your wife claims that my husband wrote this will before he died, then what do you have to, she would have to prove that this is your handwriting, this is your signature. So make sure that there is enough clarity in that. A holographic will doesn't need to be witnessed by anyone. You don't need a lawyer to witness it. You don't need some other person to witness it. However, holographic wills can be viewed suspiciously by people. For example, like if you don't give property to some member of your family, they might challenge it and it might make things very complicated. So this is why you should still consult with a lawyer, make a virtual appointment with a lawyer, consult with your lawyer, get advice. If you have a will, get it reviewed by them. And if you cannot execute it out, just write it entirely by your hand, get it somewhere reviewed, get some opinion on it, and then execute it by yourself as a holographic will and leave it for your family. But it is still advisable that you should consult with a lawyer. All right, thank you. Faisal, you can take it over from there.
Thank you very much. So the next, so those were type of wills that we briefly addressed here.
Sorry, one more thing I forgot to clarify there. A lot of people make that mistake. What they do, they download a form or something from internet or use some software, and then they sign it thinking this is an holographic will. This is not. It is invalid. A holographic will must be entirely handwritten by you. So please make sure that you don't make that mistake. All right, sorry, Brother Faisal. Yeah.
Yeah, very good. Thank you. So that's what we were going to just wrap up here. So don't think you can, as Washim said, get a pre-printed form, or you have these Muslim will site. ISNA had a form. That's not a holograph will. Those will, the same tests that a formal will go through, you'll have to comply with those. Okay. Okay. The last few things I just want to touch upon very briefly is probating. So the reason you do a will is, at the end of the day, the will help you probate the estate. Okay, so what does that mean? Probate, just a fancy word to saying, look, we'll just formalize it, legalize it. If there's a will, we'll take it to court and have a judge say, yes, they're going to review it. The courts will review it, and then we'll issue a certificate. That certificate will say so-and-so is the executor, and they can distribute the property however it's set out in your legal will. There is probate fees. So you can talk to a lawyer, and the lawyer would be able to advise you, like, some people have a complicated estate. So they have their house, they have their personal assets, and then they have corporate assets. So if everything goes through a will, anything that goes through a will, there's going to be probate taxes calculated on that at the time when you probate with the court. So there are ways you can meet with a lawyer, and the lawyer, and in consultation with accountants, usually they'll be able to structure more complex estates to say, you know what, we can minimize the taxes, whether it be probate taxes, other types of taxes that can be that are going to be assessed against your estate or the beneficiaries. Okay, so preparing for that is another reason why you want to make sure you sit down with a lawyer. I mean, we just did a will where this doctor had lots of assets, and we were managed, they initially didn't want to do all this, but at the end of the day, we try to show them, look how much money you actually saved. Yes, you spent a lot more money doing your will and structuring your estate and transferring properties and, doing a secondary will for the corporation, all that stuff. But at the end of the day, look how much money you're saving. Your estate is saving, but also the headache and cost savings for the beneficiary. So probating is what you're working towards, right? And so filing with the court, and if there is a will, then it's certificate of appointment of estate trustee with a will. If there's no will, then certificate of appointment of estate trustee without a will. Both are application that you will do. If there's a will, then we know who's doing it. The executor will do it. If there's no will, then it's a free-for-all. People may come forward and say, well, I want to be the executor. I want to be the executor, right? So we're working on a matter right now where basically the person who should be the executor doesn't want to be the executor. Okay, so person died, no will, and the surviving daughter should be the executor, but she says, well, I don't really want to get involved in this anymore. But why is it important? Because a third party who entered a contract to purchase a property, with the father, went to the daughter and said, look, I need you to be appointed executor, and I want you to transfer over this property that I have that your father was holding for me in trust. And here's all the evidence. Here's all the thing confirming that he didn't really, it's not his, it's mine. But she's refusing to. Okay, she's refusing to. So now she has to, this other woman has to go and apply to be appointed executor. Right? So, and this will be a certificate of appointment of estate trustee without a will. Right? And it's going to be much more complex because there's no relationship. This man treated this other person as a daughter and was holding this property for her. And the real biological daughter is like, well, I don't have anything to do with this. I'm not going to apply. Okay? And don't bother me about this. So you see, so all these scenarios happen because, again, when they did these transactions, they never really got proper advice. They come to us after the fact now to solve a problem, which is much more complicated. The following people can apply to be appointed as executive if you don't have a will. We suggest you have a will and you put who you want to be the executive. But in the event you don't have one, then spouse, child or children, grandchildren, parents, brothers, sisters, nephews, nieces. And in the case we're doing right now, it's a completely unrelated person, but they have an interest in the property, and this is documented, right? So we're going to have to convince the court to say, look, this person should be appointed executive because nobody else is interested, nobody else wants to, they don't want to do anything, they're not cooperating, and so we have to convince the court to appoint this person as executor. The last thing, and then we'll turn over to questions, is there are documents at the same time as you do wills. We suggest that you do power of attorney for personal care, power of attorney for property, because sometimes there's a situation where you're not dead yet, okay? So the will doesn't come into effect, but neither are you fully living, in a sense that maybe you lost your competency. Well, you can't come to the lawyer when you're about to lose your competency or you're not capable anymore to say, well, I want my father to give me the power of attorney. So, well, your father can't give the power of attorney right now because they're deemed incompetent. This has to happen before, right? So whether it be personal care decisions, medical decisions, or financial affairs, this should be done at the same time you do your will. And so if it's necessary, then we can use those. Also, a living will is another document which will allow you to control how you continue to live your life or not, okay, where you can pull the plug or not. You know, those very controversial and very delicate decisions that must happen. It's better you think of these things before you need to, because then you can have us in place. You can have these things in place. So with that, I would wrap up, unless Washim wants to throw in anything there, and then we can
Just wanted to clarify something, add one more thing to what you said about the power of attorney. I've been advised by a few clients who actually went to the hospital with their family during COVID, and they were at critical stage in ICU. The doctors were asking for if they had any power of attorney for personal care to understand like what type of treatment and other procedures to be followed. Now, understand this, now we are going through a pandemic. It's a global crisis, and you must have heard some news from Italy that doctors are choosing like which patients to give life support to, which patients they should take off. Some people are saying, just take me off of the life support and whatnot. I personally encountered a situation like this several years ago when my father was in ICU. At one point, the doctors were indirectly giving the message that he won't survive, and like he's suffering, maybe we should consider letting him go, take off the vent. But thankfully, my father recovered, alhamdulillah, he's good, he's in good shape right now. But that was I personally faced that situation. And now if you know, like how does a doctor know if the person wants to leave or not in that situation when he has no chance of survival? So you know, it's very important for you to leave instruction whether or not you want to continue with life support, as long as, you know, God allows you to remain alive, or whether or not at certain point you should be let go. So that's a very, very critical situation. And I think more people will face this situation now than ever. So that's something, this is why it's important for you to leave a power of attorney for personal care. Also regarding the property, if you are incapacitated, and a lot of people, especially in our community, they mainly maintain their business. Their wives probably are housewives. They have the bank account, they pay the mortgage, they pay everything. Now, all of a sudden, they're in the hospital, and they don't have a power of attorney. No one can manage now they have the money in the bank account, no one can access it, pay the bills. So this is why it's also very important. The same procedural requirement applies in terms of executing a power of attorney right now as wills as well. So you still need to have the witness, and everything need to be done properly. Virtual commissioning requires that. So we will wrap it up right now and go to the questions. There are some questions coming already. I think Faisal can start answering, and if I need, I can start answering as well. All right.
Where are you seeing the questions, Washim?
I could see on the chat. If you look at the right beside the participants, there's a chat about like icon.
My chat is gone.
Oh. So the first question I can read is, can you provide a sample of a holographic will, as in what exact words need to be in it to make it valid? Well, it's very hard for a lawyer to just give you a template of a holographic will, and it's actually inappropriate. But what you can do, you can look into some of the standard formats of will that are available online, and you can write something with your hand, and you can then schedule a virtual meeting with a lawyer and review, and with a lawyer saying like, did I cover anything? Did I miss anything? Should I do anything? It's because Faisal covered, right? There are a lot of like particulars, there are a lot of details that will change a lawyer's advice to you, opinion to you. And it will be unfair for us to just give a template, just do this, and then you end up in bigger mess, right, later on, because we need to know all the details, all the facts, right?
Yes, very good. So the problem with giving, a lot of people will think, you know, when they get married, when they're doing a will, they say, you know, you're a lawyer, just give me a sample. The problem is two things, as Washim very clearly explained. Your circumstances are important before we can give you something. You say to us, just give me the form. The problem is once we give you the form, we're liable. okay? Or the Law Society of Ontario will say, well, you gave that form to someone, they relied on it. Now somebody relies on it and your estate now gets into issues, they're gonna track it to us, okay? And trust me, when litigation happens, I've had my father who performs Islamic marriages and talaqs or divorce, Islamic divorces, let's say. He stopped doing Islamic divorces. Why? Because he gets sued, right? So there's lots of liability in these things, right? Because people, you may trust each other, you may trust one or two people, but it goes down a chain where you've given a document to someone, they relied on it, something goes wrong, somebody will use that document to come after. So that's why the Law Society will tell you, you can't just give out forms like that, right? So even this session, we have to make it very clear, this is a general education session. You know, it's not legal advice. Whatever answers we give you here, you can't rely on it because we don't know your full story. In order to get your full story, I'd have to have a private chat with you, get all of the information, and then you think you want to do certain things a certain way. But after I hear certain things, I say, no, you can't do that. This is what's going to happen. You need to do this. Okay? So forms are very difficult, to deal with like that.
So the second question for Faisal, how quickly can a will be when someone dies? I think the writer wanted to write how quickly a will can be executed and how quickly a beneficiary can get paid. So if you want to quickly answer that.
So it's not, the will's already executed, right? The will's already signed and the person has died. So I assume the question is the person has passed away.
Probate, I believe that's what the...
Okay, so probate, so the spouse has up to 6 months to elect. Okay, so let's say I die and I leave a spouse. Well, you don't want to probate, right? Like let's say I appoint my son, who's not old enough, but let's say he was old enough. I appoint my son the executor, okay? And I say, look, everything goes to my wife, but son, you're the executor. So, and I pass away. Now, my son will take it to a lawyer and they're gonna probate. Now, he should wait 6 months at least because the spouse still has that time to elect to say, like, I'm gonna take it under the will or I'll take it under the family law. But if I left everything to the spouse is gonna say, well, I got everything, so I don't need to wait 6 months. So in that case, the son could apply, go to the lawyer, and we could apply right away. But that means some lawyer time to meet with the lawyer, to meet with other possible people who might have claimed, to gather all of the stuff, file in court, and then of course it's up to the courts. So some courts are backlogged, and especially now after this COVID-19, we're going to see huge, already we were the most backlogged in the developing world. The Canadian courts were among the highest in terms of, worst in terms of having long backlogs and efficiency wise, unfortunately. But now with this, it's going to be even worse. So timing wise, it's going to vary and depending on a lot of things, but you're not going to see something. It's not something that happens in a few weeks. In the best case scenario, it takes months.
Yeah. So this is why it's also important because when you are, so if you're, let's say, managing properties for a minor or you have a custodian, you are acting as a custodian or trustee for a minor child's property, then it's very important that you leave a will. And because that's, there's a 90 days period that comes in based on your appointment of a will. And that could be immediately exercised because of the child and circumstance. You can make some decisions for the child while you can apply to the court for an appointment. And the problem with the timeline, it's very hard because it also varies based on the region where you're living in. For example, if you are, let's say, living in like Hamilton. Hamilton is more populated now. Let's say if you're living in some small town in, let's say, Paris, Ontario, then you probably will be a lot faster than if you're living in Toronto, Ottawa, or Windsor, one of the cities where there are more people, right? There are more, the courts are more backlogged. So that's something, but know that if you have a will, still there's a waiting period, unless if it's as simple as Faisal covered, just leave everything to your wife. You can just quickly go ahead and start that. But then if you don't leave a will, then you are in big trouble. It could take now, given the COVID, several years actually. It could take several years. Even in normal circumstances, without a will, it takes At least 2 years, actually, that's what I understand. Or the average, I think 2 years plus, right? For without a will, now it could be even higher.
Yeah, it varies according to the courts, as you said, and it varies on the backlog they have, right? So it's best to have the will, and at least it'll speed up a little bit. I see now two questions. I can kind of interrelated. I'll try to answer these interrelated. Where do Islamic wills, inheritance fit in the picture? And then joint ownership of a house. What can the spouse still distribute their share if it's a joint owner? I'll just briefly touch on them. Maybe Washim, you can jump in as well.
Sure.
So
Sure.
Islamic wills. A couple of problems. One is joint property, okay, means that most people who come to our office to do a real estate deal, it's joint, okay? So what happens is, as I explained during the presentation, the joint property has a right of survivorship, especially among spouses, okay? So it automatically belongs to the spouse. This property is not 50-50. People think, they're like, oh, you know, it's joint, it's 50-50. No, 50-50 is not joint. Joint means joint. That means 100% mine, 100% my wife's. The moment I die, my name just gets erased from there, and it's 100% my wife's. No real formalities required other than you going to a lawyer's office and doing what's known as a survivorship application. It's just an application form that the lawyer will help you complete, file with the registry, and my name is deleted, okay? But if you, and it belongs to my wife. So even if I had a will that said, hey, my interest in my property should go to my children and my brother, no effect, because right of survivorship governs, okay? Same thing, anything I have named a beneficiary to. So I have, let's say, an RSP, and the beneficiary is my sister, let's say, I'm making this up, okay? Now, in my will, I say it's going to my wife. Well, no, the will doesn't touch that because I already named the beneficiary outside, okay? So with if you want to change that scenario, you want to change the joint ownership, then you can sever the joint ownership. You can go to a lawyer's office, real estate lawyer's office, and say, look, we have this joint tenants. We want to be 50-50 or 70-30 or whatever it is. You need to do that. Once you do that, then in your will, you can distribute, say my 30% goes like this. That's where the Islamic, so people who want to do an Islamic distribution, they will have to say, okay, we have this house. From this house, 50% is mine, the husband's, 50% is the wife's. Now we'll do Islamic wills and say, for my 50, my wife will get 1/8, and you know whatever the proportions are, depending on the Islamic school of jurisprudence you apply, you follow. There's slight differences. Hanafi, Shafi, Hanbali, Maliki, or in the Shia community, Jafari, or the Ismaili, they all have different distributions. Okay, so which school are you going to follow now? Okay, so Islamic means when people come in and they say Islamic, they come in thinking, okay, everything should be equal. No, that's not Islamic, especially with your children, for instance. Okay, so you have the sons will get double the share, right? In general, okay, and the daughter will get half the share. Now a lot of people will come and say, well, I want Islamic, and then when we tell them this, they say, well, no, but that's not Islamic. Yeah, that's the Islamic distribution, okay, because it's a different system that was there. Is it? You know, some people then look at it, well, that's kind of unfair. Why does the son get double? Well, because in that system, it made sense, okay? Because in the system, what happened was the son would get double, but if you read all of the Islamic jurisprudence, the son is now responsible from his share. He's responsible to take care of the mother. He's responsible to take care of still of the daughter as well. The daughter comes home divorced. The son still has responsibilities as a guardian to that sister because he got double. Okay, but now we have two systems clashing. Imagine if I got double the share from my dad, and my sister, God forbid, is divorced and comes to, she has no way of enforcing me to help her. I can tell her to get lost, even though I got double. Okay, so in this system, you can't really enforce the Islamic distribution, but can you still do it? Yeah, you can. You probably want to talk to a lawyer and talk to an Islamic scholar, and then they would have to work together, and to do an Islamic will is going to cost a lot more because now you have to transfer the property, make it 50-50 or 70-30, whatever your ownerships are. Also detail out all of these alternative distributions in the event this person's there, in the event this person's not there. You have to set it all out. So it's going to cost you a lot more money as well. Okay, so it can be done. What I usually do when people call me for Islamic, I say, let's do a consultation, and I'm going to explain to you all this stuff. We can pull in an Islamic scholar or who you respect, get their opinion on this. And then most people end up saying, you know what, It's too complicated for me. I don't want to do it. Okay, I just want to do a simple will. Okay, so but it's up to you. You have the right to try to structure it. Washim, you want to?
Yeah, no, you are expert on this area actually, so I don't need, you covered everything. Just I'm saying one precaution to people, a lot of people are using some templates and what they're saying, oh, in the event I die, I want my properties to be divided in accordance with Islamic law, like whatever. Just one statement. Understand that this statement is not enough. It's not going to cover you, and it's going to create more complications, uncertainty in your death. And if your will is not properly drafted in considering everything, then on public policy ground, it might be found invalid. So that's something you got to keep in mind in just writing those online forms and templates and writing one statement. You better consult with the professionals. Now, there is one question regarding the disability, person with disability, inheritance and trust benefits. What are the trust and inheritance for beneficiaries? Well, yeah, the question is very vague. I don't understand exactly what the question means, but we kind of covered that. The people with disability, if they're dependent on someone, then they have a right to dependence claim in the event that the person dies and does not leave anything. Even if the person leaves a will and does not leave anything in the will for the person with disability, the person with disability still can make a claim over the estate, and the court will decide what is appropriate. So it is advisable that if you're making a will, you have someone who is disabled and dependent on you, you should consider, you must include adequate support provisions in your will for the person with disability, or give your estate enough, executor enough independence to consider the circumstance of the person with disability and make adequate arrangement for support.
Yeah, and I'll just add to that, what you can do is, if the question is the person is leaving, let's say I have a child who has a disability, who has medical needs or whatever, then there are situations where you can allow your executor to act as a trustee, to have a trust set aside. Okay, so let's say this child needs money to be kept by a trustee. We can build into the will a trust provision that says your executor or somebody else will be the trustee and will manage this person's estate, whatever they're getting from your estate. You can also, there's also much more complicated, the Hansen Trust, which is for children with certain disabilities. You can do that, and there's tax advantages to these things. But these are the things, when you sit down with the lawyer, then they will identify these things for you and say, what you need is a Hansen Trust. Okay, and this will do this for you. This will make sure that you can avoid these issues and problems. Okay, so and then if the question was, if a person with disability is doing a will, again, the same things that Washim talked about. I mean, we can do things online. If the person's not competent, okay, then they cannot do a will. Okay, so if there's mental incapacity is the issue, then of course they can't do those documents. Their guardian will do that, right? So they're the trustee or their guardian. So if somebody has been appointed already a guardian, or you have to get somebody appointed as a guardian to take care of this person. Okay.
Yep. Thank you. There's a question from someone about a person is divorced since few years and children are adult. No, there is no property in assets. Say a small amount of saving in bank account. What kind of will is best? Well, what kind of will is best for in this kind of scenario? You need to talk to a lawyer, and will is a will. I mean, what you need to do to cover your debts, liabilities, and to what do you want to do, what instructions you want to leave with the will, you should consult with a lawyer. And if you have beneficiaries, and how you want to distribute your assets. There is no, as we are saying, there is no template that we are saying that you can go. There's one type of template is better than the other. It fits you and fits not. This is not as simple. So Faisal can clarify this if I haven't.
Yeah, I mean, you need to sit down with a lawyer, okay, especially if you have complexities like this, like you're divorced, you have children from previous marriage, current marriage. Unless your children are all mature or are older and they're not dependent on you, and you don't have any assets, yeah, then you can do a holograph. Go ahead, do a holograph will, because you just want to express your intention as to, maybe you have some personal belongings that you want to distribute that nobody will need to see a will. But if you have any kind of property registered in the registry, or if you have a bank account just in your name, okay, then they'll want to, before they disperse that, they'll want to see a will. There are situations where, for instance, we've had a sister who came to us, and she had, the husband had no assets, only had $60,000 in the bank account, didn't do a will. Now, technically, she would have to do a probate application for certificate of appointment of a state trustee without a will. But in this case, what we did is, but it depends on the bank. The bank could have taken the hardline position and said, no, we want a certificate of appointment. But in this case, we reached out to the bank on her behalf, and we said, look, it's going to cost her so much money to probate this estate. She's a single mother. She doesn't really have much money, and we don't want her to spend all this on lawyer fees, although we would like it, but it's not fair to her. Okay, so can we do something? So what we did is we ended up writing a letter to the bank, because that's the only asset the husband had, the $60,000 in the bank account. We wrote a letter to the bank on our letterhead, basically. So we had to sit down with the client and say, look, this estate only has $60,000, and we know under the Succession Law Reform Act, up to the first $200,000 goes to the spouse anyway. Okay, so there's only 60 here. We're giving you the legal opinion that this all belongs to the wife, and then we got affidavits signed by all the kids saying, yeah, this is the only only children. We're the only children. This is the wife. This is the only mother. Blah blah. This only wife and mother. And so then they accepted, but they don't have to. They could insist. You know what? We don't care. We don't want to. We need something from a court. Okay. So you need to talk to a lawyer to see in your situation how to do what kind of a will to do there.
Also, I think some banks do allow you to, they have their own documents that they could, through which you can actually nominate someone as a beneficiary in the event of your death,
yes.
Which probably is the most efficient way to do it.
Yes.
Contact your bank and find out if they have this. So at least at your death, your family won't have to go through what Faisal just described he did for a client, right? They can.
And to just jump on to what Washim just said. So if, let's say you have money in the bank, somebody's asking the question, inheritance tax. There's no inheritance tax per se here. There's probate taxes, they call it, which is a application fee that the court charges. It depends. The value is based on the value of your estate. So if you can exclude as many things as possible from going through your will, that will reduce that probate tax. It's not an inheritance tax, okay? So it's a probate tax. So if I have $1 million in my estate, then it's calculated on the $1 million. But if I can show, look, only 500,000 is the real estate, which I need a probate certificate to transfer, but all these other things I've named beneficiaries just before you pass away, make beneficiaries to them or make a joint, it's already theirs, then you're not gonna pay this tax. So this is the kind of advice the lawyer is gonna sit down and tell you. So if somebody walks into my office and says, look, I have this fully paid house, I have probably like 3 weeks to live, okay? What did I do? What do I do? I'll say, well, you can do a will, but you know what you can do? You can just, why don't we just gift all of the portions to your kids? You keep 1%, 99% is gifted to your children. You keep 1% to make sure, like, God forbid, what if you, not God forbid, hopefully maybe your life gets extended. You're not living for 3 weeks now. And so you don't want to lose full control of the property. You have 1% with an irrevocable power of attorney by the children to you. So they have 99%, but it's not really theirs because you still control it as long as you're alive. Upon your death now, only this 1% gets conveyed through the will. Saved a lot of tax, especially the rate at the rate of real estate prices now. You could save a lot of money like that, right? So, but who can give you that advice? Only when you sit down with a professional who can evaluate everything and say, in your situation, maybe this is something you could do. And we'll give you that option. We won't tell you to do what. We'll give you, if you do this, here's what happens. If you do this, here's what happens. What do you want to do? Okay, here's the pros and cons of doing it, these risks of doing it this way, the risk of doing it that way, whatever it is. But you know, you can, that's why it's hard for us to give you, here's a goodwill, please follow it, right?
Just to add something to Faisal just said quickly, a lot of clients come to us, oh, I just want to do a quick, simple will. I just don't need anything. and I just want to do a simple will. And you know, often we have to, for the client's insistence, have to do a vague will without taking account all this stuff. What we have to do is like write a vague will with like, in the event of our death, all property gets 1 share to this, 1 share to that, 1 share to that, right? What it actually does is that it brings almost all of your assets under the will, and then at the probate, you end up spending more money. So if you could speak with a lawyer, spend more money at the time of your estate planning before you die, when you are doing your will, you properly plan your estate and do it that way, you would actually end up saving a lot more money when you will need the money the most. Because this savings at the beginning, some money, some lawyer fees at the beginning at the time of will execution would seem insignificant actually at that time. So question for Faisal, somebody asked about whether or not people who are not living in Canada can be beneficiaries, and how would they access the estate under will?
Yeah, you know, beneficiaries can be anywhere. They can be overseas, they can be non-residents. The issue is with executors being foreign executors. That's when you have to do the bond. But beneficiaries, I mean, so the executor will look at your will. Once they've got the certificate of appointment and they're the executor, now they have everything. Okay, they hold everything, and they basically say, okay, let me look at the will now. So so-and-so, the long lost cousin in India gets this much. Well, that's for them to now take that money or whatever it is and send it to India. And then there may be implications over there in India. Okay, I don't know the laws in India. Somebody receives a gift over there. Is there a gift tax? Is there inheritance? I don't know, right? But they'll have to get that advice there. But in Canada, yes, you can, you know, distribute to whoever. There was one question here. This is somebody, sorry to repeat this again, but just to clarify, do all wills need to be probated? So I'll answer this, and then Washim, you can take over.
Sure.
No, okay, so wills have to be probated if there's a need to probate them. So at the time of a person's decease, again, you will take that will to a lawyer, and the lawyer will talk to you, and depending on the circumstances, we say, you know what, you don't need to probate this estate. But it depends on various factors, okay? So for some things, you definitely will have to, based on your explanation of your facts, the lawyer will say to you, yeah, you know what, you have a real estate property here, which we need to go to the registry, and the registry is going to want to see the certificate. So you got to probate. But let's say you don't have a real estate property, or it was joint, okay? Well, then you don't need to probate, because we'll just do a survivorship application. But what about other things? And maybe the bank, okay, might say, you know what, we don't need a probated will. We just need a copy of your will, and maybe your lawyer can write a letter saying, you know, that there's only less than 200,000 and you're the spouse, so everything comes to you anyway, so we don't have to go and probate. But if it's more than 200,000 in the person's estate, then we're going to have to probate. Okay, so it all depends on the circumstances whether or not a will has to be probated or not.
Yeah. So there is actually one question, Brother Faisal, that you will also have to answer. Some brother, I think he's a little disappointed about our comments on Islamic will. So just to clarify, we are not saying that we don't do Islamic will. In fact, we are encouraging people to have a will, which is itself an Islamic practice. What we are saying is we are giving you a lot of precaution and asking you to not to make the mistake that a lot of people make and then come to us for our help, and it's very difficult at that time to help them. One of them is a very common mistake that people make is download a form from some website and say, this is an Islamic will, I want to distribute it that way, sign it, and later on it gets into it gets challenged, and there are more issues coming out of it, and everything gets messed up because the beneficiary who need the money, they're not getting it because they have to litigate the matter. So that's what we are saying. We are happy, and we are working very hard, actually doing more research and finding out options, how we can develop, have certain clauses, certain strategies we can take to make a will more Islamically compatible for our client. Indeed, we serve the largest client base that both of us have are coming from our Muslim community. Now, but one truth that I want to tell, that's my opinion, you have to take it or leave it, or Faisal can jump in. I don't think there is under the current framework, you cannot truly say there is something called Islamic will. What it is actually Islamic estate planning. Yes, if you are prepared to do it, if you're prepared to sit down with a lawyer and plan your estate properly and you do take all the necessary steps to have it Sharia compliant distribution at the end of your death, that can be done. Though it is complicated, can be done. But just expecting that just you write a will with a simple statement and your estate will be distributed in accordance with Islamic laws and principles is not realistic. And that's what we are trying to tell you. So Brother Faisal, please comment on that.
Yeah. So yeah, exactly what Wasim said. I agree with with your opinion 100%. So you cannot do a Islamic will, a simple Islamic will and say it doesn't work. There's going to be multiple issues. And in the future, we're also going to see, if you did that, you're also going to see all kinds of things in the media, okay, where people are going to be, Islamophobes are going to be targeting, especially with this distribution, which I explained to you. It made complete sense if you're living in that holistic system. The Islamic will made complete sense. But when people are picking and choosing what they want to do Islamic, it comes in the divorce context as well. Okay, when it suits them, they want to apply Islamic. When it doesn't suit them, so that kind of mixing and matching foreign shopping is what we're saying. Don't do that, right? Now, you can do Islamic estate planning, yes, but it's much more involved, much more costly. And both parties, if you're married, both parties, and if you have interconnected assets, both parties have to agree. A lot of times people will come in and one person's like, I want Islamic. And the other person's like, no, I don't want that, right? Okay, so now how do you do that? Because you're also holding properties together, right? And you have to, so it's much more complex. Can it be done? And will we help you? Of course we will. We're, at the end of the day, we're business people as well, right? If you're going to give us a complicated problem and you're willing to pay our time to solve the problem, hey, Wasim, I'm sure you agree. We will take your fee and we will help you and we will structure those things. But most people, when they hear that, oh, this is too complicated, they just, but that's not our fault. We are willing to help you. We say, look, but you need to do all of this, right? The first thing is, when simple couple comes and they say, we want Islamic, and we say, okay, well, you own property jointly. Who owns this? So now they look at each other, and then one person's thinking it's 50-50, the other was like, well, 60-40. So well, you guys need to figure out what the ownership of this is first. Then we can divide that. Then we can do wills to distribute your respective assets, right? So that's just a very simple thing I'm telling you. But there's much more complexity when it comes to trying to do the Islamic. Are we against doing it? No. If you want to do that, we have religious freedom here, okay? And we will try to work with you, but it's much more involved. And I like the word Wasim used. It's more like Islamic estate planning rather than Islamic will. Now, I see a lot of people come here. They've gone to non-Muslim lawyers, and they've told them to do an Islamic will. And I look at it and I'm like, what? It just says Islamic will, and they have Bismillah on the top. And then distribution is everything to the spouse. Okay, and then and kids. So it's like, okay, what's Islamic about this, right? So, and they're just being like, because they themselves don't know. So I'm going to be honest with you. Wasim's going to be honest with you. This is what Islamic would look like. Do you want that? No problem. We'll try to structure it, and But if that's not what you're thinking, if you're thinking something different, but you're putting the label Islamic on it, okay, well then, then we're going to tell you that that's not really it. Okay. Any other?
Yeah, I think we need to conclude this now. We are
Over
12 minutes beyond our allocated time. 3:30, I think we're supposed to finish, right?
Sure.
But there's still, I see a lot of questions and interests are coming. Maybe what we can do, first of all, this video I think will be shared by CMLA publicly, so a lot of people who missed it can watch it. Some people are asking questions that we already actually answered, so you might have come late or something. You can
what we can also do with Wasim, maybe you can do the same. What we can do is we can take some of these questions, and over time we can try to answer some of them on blogs or whatever, like give general
yeah, or even this
information.
event page. I think the CMLA has an event, right? Event page.
Okay, good.
On this event wall, we can share some of the answers.
Yeah,
right?
That's what we'll do, and we'll try to do this again another time. We'll let the CMLA take charge of that. So sorry. So thank you very much for participating and attending the event. Hopefully there was some benefit here, and Wasim does a lot of work in the community. He'll be willing to help you guys with this kind of work. Same with ourselves. Wasim, you want to close out?
Sure. Thank you very much. We really appreciate all of you joining today and showing your enthusiasm for this topic. Thank you, CMLA, Canadian Muslim Lawyer Association, for hosting this event and organizing it. It's really a pleasure. And if anybody needs any help, please feel free to reach out to us. Our information can be found online, the way you found this event. Also, if you need anything else, any suggestion, feedback, you can send to CMLA.